All right, welcome everybody to another question and answer session on a Friday afternoon. My name is Samara Belitzky. I'm an employment lawyer with Samfiru Tumarkin. I work out of the Ottawa office in Ontario. I'm going to be here for the next 30 minutes or so, as always, to answer your questions. So any questions that you have about employment law, workplace issues, workplace rights, health and safety, layoffs, paid sick leave, which we now are going to be having in Ontario to a certain extent. Anything at all, if you've been thinking about something you wanted to ask, now is the time. As I said, I'll be here for the next half hour or so in order to answer all of your questions. So send them in. Don't be shy. Now is the time. If ever you're not wanting to send your question in publicly, or if we don't get to your question this afternoon, then you can always contact us directly by going to employmentlawyer.ca. Again, it's employmentlawyer.ca, where you can find all of our contact information. So you can contact any of our lawyers there. You can contact myself. All of my contact information is there. And you can always call us or email us through that website and getting our information there. So I'm going to, as always, I have a list prepared of a few things to go through for today. I always have a few things ready to talk about, things that a lot of people might have asked in the last week or so, issues that have come up in the news. I have a list of a few what I call workplace red flags with respect to COVID-19. I started to go through the list actually, I think it's about a month ago now, where I started to go through it, but we got so many questions that I didn't actually get to continue in the list. So as always, I'll answer your questions as they come in. I'll go through what I wanted to talk about in the event that I don't have questions coming in right away. And that way, if you're watching this, issues that you might be dealing with, issues that family members might be dealing with, or friends, hopefully that will assist in dealing with any of these very common issues that have to do with COVID-19 in the workplace right now. So I'll start going through my list and make my way through. As I said before, if you have any questions, please send them in. I'm happy to answer all of your questions, and I would much prefer to answer your questions than go through my list. So please do send in your questions if there's anything on your mind. For those of you who are just joining us, anything related to employment law, anything related to the workplace, health and safety, layoffs, constructive dismissals, severance pay, any issues at all, happy to hear those issues and provide guidance on those. So I'll now get to the couple of COVID issues that I wanted to mention, because these are things that come up very often. We get lots of people asking us these questions, asking us about what to do if they're in a situation like this. And so the first thing on my list that I actually covered a few weeks ago, I'll mention it briefly just because I actually did have somebody email me this week with a very similar situation. So I know that this is something that keeps coming up, and I think it's going to continue to come up throughout the pandemic and maybe even beyond. And that's an employer bringing somebody back from a temporary layoff and asking them to sign a new contract. So I've been seeing that, and my colleagues have been seeing that very often throughout the pandemic. And so what's very important to know, and I won't get, like I said, I won't get into too many details because I did talk about this a few weeks ago. But what's important to know is that you don't have to sign a new contract in order to return back to work. So if an employer calls you back from a temporary layoff, you want to go back to work, you don't have a contract in place, or you already do, but they want to put a new one in, you don't have to sign that. An employer cannot make you signing that new contract part of the conditions for you coming back to work. They'd have to bring you back to work to the same position, same pay, same hours. Everything needs to be the same. And the contract is not a condition. So if you're in a situation like that, you don't have to sign that contract in order to go back to work. And in fact, you probably shouldn't sign that contract, at least not until you get it reviewed by an employment lawyer. So I see I have a question coming through from Facebook. Tigers Rangers is asking from Facebook. He says, or she, or they, I'm not sure. I am pursuing a human rights case if I was working reduced hours due to being harassed, would it be reasonable or normal to ask for lost wages as damages? Well, that's a very good question. So in terms of your human rights application, if your human rights application, the basis of the application is harassment based on one of the grounds that's protected by either the Canada Human Rights Act, the Canadian Human Rights Act, or the Ontario Human Rights Code, and that caused you to have to work reduced hours, then it can very well be part of the damages that you claim in your human rights application. So if in fact it was because of the harassment, and you have medical evidence that supports that, then you can include that as part of your damages. What's really important to know in a situation like this is you do have to have the medical evidence. You do have to have support from your treating physician that specifically says that the only reason for the reduced hours was because of the ongoing workplace harassment. So there needs to be that nexus, that connection between the discriminatory treatment or the harassment that you did experience in the workplace and the fact that you had to reduce the hours that you were working, and you have to provide medical in that regard. Your word, unfortunately, is not good enough in terms of having to prove those damages. It has to be proven through medical evidence. And if you do provide that, if there was harassment in the workplace, the tribunal finds that there was harassment, and you have medical evidence that shows that the reduced hours were a direct result of it, then you should be successful in claiming additional damages for some lost wages during that time. I'm going to move to the next question that I have here. This is a question from Rochelle on Facebook. Rochelle says, I have a question on behalf of a family member. What if someone has been promoted during the pandemic and told that they would be receiving their new salary and a merit bonus in the new year, but now the role has evolved even more and they have been informed that they will not receive their retroactive pay / bonus after all? The company is publicly traded and is making revenues / providing bonuses to other employees. So sounds like a very interesting situation, Rochelle, and an unfortunate one at that. So this would depend on exactly what was said and when, and whether any of it is in writing as well. So based on some of the information you provided, it sounds like there would be a new salary in the new year. I would need to know if that actually took place. Did the individual in question actually receive the salary like they were supposed to? If it's the case that they did and they started implementing these new terms of employment and they just didn't do the bonus, and the bonus is the issue that they're now not wanting to pay out, then definitely there would be options for recourse there. That would be an employer not fulfilling the terms and conditions of employment. See here, Rochelle, you're saying no. So it sounds like they didn't implement any of these terms. Now, if they didn't implement any of the terms and it was supposed to be effective as of January 1st, we're now May 7th today. And if it's a family member of yours, this family member hasn't actually taken issue with it, hasn't outright expressed that they were supposed to receive these items of compensation and didn't. If it was just a situation where it was business as usual and they kept working without saying anything, they may very well have potentially lost the ability to push back. And that's because if you've watched any of our TV shows or heard us on the radio, the one thing that we stress all the time is that you have to act quickly. Time is always of the essence. So if a change is supposed to take place and it doesn't, or if the reverse happens where a change takes place that you're not okay with, you need to act right away. You need to get legal advice from an employment lawyer right away, because if you don't and you keep working business as usual, then you can be found to have accepted it. It could be what we call a deemed acceptance. So if that's the case, Rochelle, for your family member where they haven't pursued the issue at all, they haven't put anything in writing in terms of dealing with this issue since January when these terms are supposed to be implemented, depending on the circumstances, there may be an issue there with the time passing and there might be a deemed acceptance. However, if the employer did put something in writing, if it's been made very clear that these terms were supposed to be implemented, if your family member then followed up on these terms when they weren't implemented, then there's a continuation of, I'll say, the situation, the discussions. There would be an express statement or something in writing by your family member where they take issue with it. All of those things would lend themselves to having a stronger case against, in favor, I should say, of getting those terms implemented. So it's really fact specific whenever we're dealing with issues like this. The circumstances of your family member's situation will essentially govern how we would recommend that they deal with this. And there can be a whole wide array of different ways that you can deal with this and try to get those terms implemented. So I would recommend, Rochelle, that your family member get in touch with us. They can contact me directly by going to employmentlawyer.ca. All of our contact information is there. They can also email help@employmentlawyer.ca and contact us that way, because we'll want to get all of the information about this situation so that we can properly advise your family member on how best to deal with this and what options she might have at this stage, or they might have, to deal with this. So I'm going to move to another question here. So I just have a follow-up question here just about deemed acceptance. So there is no actual amount of time that's written in the law that says after this much time, it's a deemed acceptance of, let's say, your boss changing your hours or changing your compensation if you don't say anything and you continue working. However, what the case law generally tells us is that you need to act quickly. So if there's a change and you go about it, you keep working, you don't express your displeasure, you don't express your rejection of that change, and then you decide that you want to reject it 6 months later, that's too late. You'll be deemed to have accepted it. The change would have had to happen 6 months earlier. So sometimes when there's a situation where your pay plan might change, but the actual change in what you're earning doesn't happen until many months later, that's a different situation, because it starts, I should say, the clock starts ticking from when the change is actually apparent, when it's evident. So if your boss tells you we're going to make this change, then you know it's going to happen. If they tell you they're changing your pay plan, but the actual decrease in your compensation isn't obvious until maybe a couple months later, if you're, for example, a commissioned salesperson, then the clock would start ticking at that point. Once you actually realize, okay, we have a problem here, my compensation has been decreased significantly. If the actual change is obvious right away, if it's cutting your hours in half, you need to actually express a refusal of that right away. And your leeway is maybe a few weeks at the most. So if you mull it over for maybe a week or two, you get some legal advice from an employment lawyer, and then you refuse the change after maybe a week or two, then you wouldn't be in a situation of a deemed acceptance, because there is a recognition that you do require a little bit of time and in order to figure out if you're going to accept the change, get legal advice so that you can make an informed decision. But in the exact same example, if your hours are reduced and you work those 50% reduction on your hours for several months, you've then lost the ability to refuse it later on. Additionally, if you sign something right away or within the first couple of weeks, then absolutely there would be an acceptance there as well. It wouldn't be a deemed acceptance, but an acceptance outright if you're signing something. The only exception to that would be if the employer makes you sign it right away without having the chance to seek legal advice, then there are exceptions to that. So I have another question here that I'll get to. So Evelyn from Facebook says, temporary layoff due to COVID and would like to wait till July to see if I get called back. So I'm not sure if I missed maybe part of the first part of your question, Evelyn, but what I can tell you about your layoff is if you are being laid off lawfully or you've accepted a layoff right now, under the Employment Standards Act, under the new regulation, the Infectious Disease Emergency Leave, then that expires on July, I think it's July 4th, so within the first few days of July. So if you're not called back to work, Evelyn, yourself, or anybody else in this situation, it becomes a regular layoff after that. So we're back to the regular layoff rules under the Employment Standards Act, as long as the government doesn't extend infectious disease emergency leave again. You're in a situation where in July, you absolutely could, you absolutely could pursue a situation of getting returned back to work immediately, and if not, going after severance pay. Again, that's if you've accepted the layoff or if the layoff is lawful to begin with. If you're in a situation where the employer is not allowed to lay you off, which means you haven't signed anything previously or now that says they're allowed to lay you off, and you have never been laid off previously and then returned to work, that means the employer actually isn't allowed to put you on a temporary layoff, and you don't have to accept that. You can actually treat that as a constructive dismissal, as a termination of your employment, and you can pursue your termination entitlements, your severance pay. So when we're talking about the infectious disease emergency leave, as I just mentioned, and the July date that we were talking about based on Evelyn's question, that is only for folks, and this is a very small portion of people, but folks who actually have accepted a layoff or whose employers were allowed to lay them off from the get-go. I have more questions coming in here that I'll get to. So Mad Peddler from YouTube asks if I can elaborate on frustration of contract and whether an employer can use this with regards to COVID, not to pay severance. That's a very good question, and it's an issue that we've been dealing with since, I'd say almost since the start of the pandemic. So frustration of contract, it's a contract law principle where in general, I won't apply it to employment law yet, but in general, excuse me, where the parties to a contract, for one reason or another that's outside of their control, that was unforeseen, one of the parties of the contract can no longer actually carry out the obligations under the contract. That's kind of a general explanation. When we apply it to employment law, the most often, the scenario that we most often see where there's frustration of contract is in a situation where an employee actually cannot do their job anymore because they're on medical leave. And that's not a medical leave that is a short period, but a medical leave where somebody will likely never be able to return to work. So in that context, when we're talking about a frustration of contract due to medical reasons, you most often see it where an employee has been on medical leave for maybe 4 or 5 years. I'm not talking months, I'm not talking a couple years, I'm talking at least 3-4 years, and we often only see it beyond that time. And the employer checks with the employee and with their doctor, and their doctor says, no, this employee cannot come back to work in the reasonably foreseeable future. And if that's the case, and that employee will not be able to return to work, we think ever, the employer can actually claim frustration of contract because the employee can no longer hold up their end of the employment contract by carrying out their job. And in a situation like that, that employee would be owed their Employment Standards Act notice, so their minimum termination entitlements under the Employment Standards Act. It's not that they're owed nothing, it's just that they're not owed their full entitlements at common law. Now, with respect to COVID specifically, we have seen some employers take this position and make this argument that because of the pandemic, so again, due to no fault of their own, due to the pandemic, due to potentially a decrease in their revenue or a government order shutting their business down, that the employment contract has become frustrated because the parties, either of them, the employee or the employer, cannot carry out their obligations under the employment contract due to no fault of either of the parties, but simply because of the extenuating circumstances that were unforeseen. Now, that's a very exceptional argument because in most cases, an employer is going to have a very, very tough time and a very uphill battle in actually proving frustration. So as I mentioned before, a lot of employers are taking this position in order to get out of paying severance to their employees. So this is something that we've been dealing with very frequently where an employee is terminated, a client of ours is terminated, they're offered the minimum, the bare minimum under the Employment Standards Act in Ontario, for example, and the company references that it's because the employment contract is frustrated because of COVID-19. It would only be in very, very specific circumstances that that argument could potentially be successful. We haven't seen it yet. So no company, as of today in Ontario, has been successful in making that argument. And that's because a lot of these cases haven't actually gone to court yet. It takes a long time for cases to get to court. So if a company took the frustration position, let's say last summer, it may be that the case, if it does actually go to court and it doesn't settle, only gets heard in the next few months. But as time goes on, I think we are going to start to see these cases come out. We're going to see more of these frustration cases go to court, and the court's going to be able to give us guidance on whether they're going to change the criteria for COVID-19. In other words, the frustration of contract legal doctrine exists already. That's what should be applied to the COVID-19 analysis, and we'll wait to see from the courts if they're going to change that at all. But what's really important to keep in mind, especially, I'd say there's a takeaway for both sides here. If you're an employer, you have to be very careful in taking the position that the employment contract's been frustrated, because in most of the cases, it hasn't been. It's a tough situation. The pandemic has certainly affected a lot of businesses financially, but it doesn't mean that there's a frustration of contract. And in a lot of the cases that we deal with, most of these employers have taken the position of frustration very prematurely. So, for example, they took a frustration position in May of last year when we were only a couple months into the pandemic and nobody really knew what was going to happen. So if you're an employer, you want to be very careful. You want to make sure that you get proper legal advice from an employment lawyer to make sure that if you're going to take a frustration position, you actually have a legal leg to stand on, because in the vast majority of cases, you won't. And as an employee, the takeaway here is if you're an employee and you are let go and you are told that the employment contract is frustrated, you need to get legal advice from an employment lawyer right away, because as I said before, the odds are that the employment contract was not frustrated and you're owed much more severance pay than what the employer is offering you. I'll just get to, there's some more questions here. So Brian from Facebook asks, is an employer required to provide a reference if you are dismissed from your job, or can they avoid this, which might prevent you from obtaining gainful employment? A great question, Brian, and one that I get actually pretty often. So the short answer is no, they're not required to provide a reference. So when we're talking about references after a termination, there is no legal obligation for an employer to actually provide a reference. Good, bad, neutral, they don't have to provide any sort of reference. Of course, it's going to potentially impact your ability to get another job, because your prospective new employers may be looking for a reference. So what I usually recommend to my clients is, if the company itself will not provide a reference, and most don't, the vast majority do not these days, if they will not, then you try and find yourself a personal reference from your previous place of employment. So a manager or a supervisor or simply a coworker that worked with you that can vouch for yourself in the workplace, your skill set. And that wouldn't be somebody who's providing a reference on behalf of your former employer on behalf of the company, but they would be doing it in a more personal capacity, which is just as valuable, if not more valuable, to a prospective employer. So that is what I would recommend to someone if the employer, the former employer, will not agree. Most of the time these days, what they will provide is a confirmation of employment letter, which just confirms that you worked there, what your position was, maybe what your duties were, and what your tenure was. So from what date to what date did you work there? That's usually sufficient for the purposes of applying to jobs. But if you do want, a reference, or if your prospective employer needs a reference, then I do recommend to do exactly what I just mentioned by looking for those personal references, simply because most employers these days will not comment on performance, good or bad. So they won't give you a positive reference or a negative reference. They'll just confirm that you worked there. So I will get to another question here. Steve from YouTube says he's been permanently laid off June 25th, 2020 due to COVID. How long before our right to fight it at HRTO or small claims expires? 1 year from that June date, or would it be prolonged under the Emergency Leave Act? Another great question. So when we're dealing with, so I see you said you've been permanently laid off. You're asking, Steve, about the Human Rights Tribunal of Ontario, the HRTO. If there is actually a human rights allegation here, which is unclear, if you were just simply terminated and there is no allegation of discrimination based on any of the code protected grounds, then you wouldn't be filing any claim at the HRTO, at the Ontario Human Rights Tribunal. You'd be suing them in court. Okay, so with respect to any human rights allegations, you have a year from the last act of discrimination or harassment or whatever act is or conduct is being complained of under the code, under the Human Rights Code of Ontario. You have a year from that last date. So if in fact there is a human rights element to this, Steve, and you were let go on June 25th, and you think that part of the reason for your termination was a ground that's protected by the Human Rights Code, you should move ahead with that as soon as possible, since we're May and your limitation period would expire a year from June 25th of last year. So you're coming up on your limitation period for human rights. And similarly, if you decide to sue in court, which is usually my recommendation if you have a severance pay issue and a human rights issue, it's usually better to go to court because you can actually address both at the same time. So you can file a claim for severance pay and human rights damages and have that go before the court. So that would be my recommendation. Similarly, you have a year for the human rights allegations. So just because you're going to court doesn't mean that that limitation period gets extended. So if you do decide to sue in court, if you do want to have the ability to be successful in receiving human rights damages and not being out of time, you have to get that claim issued by the court by the limitation period as well, by that 1 year limitation period for human rights damages. In order to file civil action, so if you're just going after severance pay, that's 2 years. So the limitation period in Ontario for filing any claim in Superior Court, a civil action, is 2 years from the date that the damages are either discovered or occur. So with respect to terminations, it's the date of termination. And so you'd have 2 years from June 25th of 2020 to file a wrongful dismissal claim in small claims court or Superior Court, depending on the situation. The difference is that anything that is claimed in the amount of $35,000 or less would be in small claims court jurisdiction, and anything that's beyond $35,000 would go to the Superior Court of Justice. The small claims court, the advantage there is that the process is much more streamlined. There's only a few steps in the process, so you can usually get to a hearing much faster, as opposed to the Superior Court, where there are more steps to carry out if you're going to go all the way to a hearing, for example. The other advantage to small claims court is that you can represent yourself as an individual. In Superior Court, you would be represented by a lawyer, and so it can be a lot more expensive depending on the circumstances. So Steve, I see your message, you're welcome. If you did want to chat about this further, definitely get in touch with me. I can always give you further advice about where you might want to file a claim, but you definitely want to hurry up and take action as soon as possible, given you're coming up on that notice period. All right, we're just getting to the end of our time here, but I'll answer one more question and then we'll leave it at that for today. So Mark from Facebook says or asks, if a former employer misclassifies the reason why the employment relationship ended on an ROE, a record of employment, can that be grounds for seeking damages? I'm thinking here of an employer who lays someone off for a shortage of work, but then classifies the layoff as a dismissal on the former employee's record of employment. Another great question today. So this is another question I get a lot. So in terms of the record of employment, it doesn't actually have an impact on any sort of determinations of entitlement. So what I mean by that is As long as your record of employment has code A for layoff or code M for dismissal, you will be entitled to receive employment insurance benefits, EI benefits. So whether it's one or the other, and I often see when it's a termination rather than code M for dismissal, I often see code A for layoff, because employers, a lot of them are under the understanding, and it's correct, that if there's a code A for layoff on the record of employment, then you would be automatically entitled to EI benefits. And that is correct. And so a lot of times, even though it's a dismissal, employers will put code A because they're trying to help that person out. But the same is true of code M for dismissal. If there's a code M for dismissal, you will as well be entitled to EI benefits. It doesn't say dismissal for cause, it just says dismissal. It doesn't actually distinguish between whether it was cause or without cause. So most of the time, Service Canada will assume it was without cause, and there won't be any actual negative impact. Either way, if we're talking about those two codes, there will not be a difference to whether you can be in receipt of EI benefits, and that is the only actual entitlement or item that would be impacted by the code on your record of employment. It won't impact you in any other way. So as long as it has one of those codes, there is no issue. And to answer your question in general, Mark, there aren't any grounds for seeking damages if they put one over the other. And it does sound like, I'm just looking at your question again. If somebody is laid off permanently, even if it's for shortage of work, then it's still a dismissal, and code M would actually be the proper code on the record of employment. But again, as long as we're looking at a code A for layoff, shortage of work, or a code M, that person will get approved for benefits, for EI benefits through Service Canada. So there is no kind of negative impact or repercussion there. I see there's some more questions coming in. Unfortunately, I do have to end the session at this time. What I will say is, if we didn't get to your question this afternoon, please do contact us offline. You can email me directly, you can call me directly. All of my contact information is available at employmentlawyer.ca, as well as all of the other lawyers of our firm. And again, you can email help@employmentlawyer.ca as well if you want to send your question directly to us. So thank you very much for joining us today. Thank you for your fantastic questions this afternoon. And I will see all of you in the next question and answer session. Take care.